Hey guys, my name's Joel Williams. I'm a Georgia lawyer that protects crime victims and negligent security cases all over the state of Georgia. My firm, Williams Elleby, helps crime victims that are injured at places like apartment complexes, hotels, gas stations, and pretty much any retail establishment that doesn't have adequate security measures to keep you safe. Oftentimes, crime victims have never even heard of a negligent security case. So how do you know if you may have a case? First, if you were assaulted, shot, stabbed, or hurt by a criminal in a high crime area, you may have a case against the property owner or manager. The most common example would include when this happens at an apartment complex or hotel, and that apartment complex or hotel doesn't have reasonable security in place to keep you safe. So how do you prove that a property owner should be liable when you're shot or perhaps raped on their property? Well, first you have to show that the property owner should have foreseen that this crime is going to occur. In other words, they knew they had a problem with crime on their property. So how do you prove that the apartment complex or hotel should have known about what was going to happen? Well, first, there's a ton of publicly available information. You can contact the police department, you can contact 911 call centers, and you can ask about prior crime. You can consult with the tenants of the apartment complex or guests at the hotel who were victims of crime. You want to do this to find out whether they notified the property owner or manager about the incident where they were a prior crime victim. Once a lawsuit has been filed, you can go and look at the internal incident reports from the property itself. This all tells you what they knew or should have known about the prior crime. Then you can determine whether they acted appropriately to protect you. Negligent security cases are really just premises liability cases. In Georgia, you have to prove things that are very similar to what you would have to prove in, say, a slip and fall case. Number one, crime was occurring on the property prior to your attack, i.e. the criminal activity, just like an unmarked freshly waxed floor, is a hazard. Number two, the landowner or occupier had actual or constructive knowledge of the crime, i.e. the hazard. 3. The landowner or occupier did not act reasonably to guard against, eliminate, or warn about the hazard. And 4, you have to prove the amount of your damages. It's important to note that these are the elements that must be proven when you are a business guest of the landowner, i.e. a tenant, a hotel guest, or a customer at a business establishment. Different rules apply for social guests and trespassers. If you've been seriously injured or a loved one's been killed due to criminal activity at an apartment complex or a hotel or any other business establishment, call Williams Elleby today at 833-LEGAL-GA, 833-534-2542. We've protected a lot of innocent crime victims and recovered millions of dollars for those crime victims and their families over the past few years. You can learn more by visiting our website at gatrialattorney.com.